Hello friends, welcome to Law and GK. So friends, on this channel we discuss the contents of law and previous year papers of judicial services and other legal exams. And friends, in today's video, we are going to discuss all the questions of IPC which came in the exam paper of JHARKHAND Judicial Services from the year 2008 to 2018. I hope कि ये वीडियोस आपके लिए बड़ी यूजफुल रहेंगी. So friends, if you are preparing for judicial services, this channel will be very useful for you. आपके लिए बड़ा ही beneficial रहेगा. And अगर आपको ये वीडियो अच्छी लगी हो तो जरूर लाइक कीजिएगा, शेयर कीजिएगा अपने फ्रेंड्स के साथ. And don't forget to subscribe the channel. And while subscribing, don't forget to press the bell icon so that you can get the notification of our upcoming videos. Next 82. In kidnapping, consent of minor is wholly immaterial. A is the answer. Where is the provision of kidnapping? Section 360, 361. Next 85. A finds the key of B's house door which B had lost and commits a house trespass by entering B's house. Having opened the door with that key, A has committed the offense of housebreaking. D is the answer. See, I have also made the formula for this. CT, ST, LHT, LHT, BN, HB, HBN. How? Criminal trespass 441, house trespass 442, lurking house trespass 443, lurking house trespass by night 444, housebreaking 445, and housebreaking by night 446. So this is illustration of section 445. D is the answer. Next 86. What punishment may be awarded to the person whose act is covered under general exception of chapter 4 of IPC? No punishment, obviously. If somebody falls under exceptions, it is no offense, no punishment. A is the answer. Chapter 4 is from which section to which section? Section 76 to 106. Next 87. In which of the following landmark cases a 3 judges bench of Supreme Court prescribed 4-point test relating to section 30, section 300 of IPC? It is Virsa Singh vs State of Punjab. A is the answer. Next 88. Inducing a person with dishonest intention to part with his property by putting him in fear of physical injury amounts to an offense of extortion. C is the answer. It is mentioned where? Section 383, theft in 378, criminal misappropriation 403, criminal intimidation 503. IPC. Next 89. A sees B drowning in the river but does not save him. B is drowned. A has committed offense of murder, abatement, suicide या फिर culpable homicide. No offense. भाई उसकी मर्जी है, बचाए ना बचाए. D is the answer. अब खुद मर जाए तो. Next 90. Common intention signifies similar intention or pre-arranged planning. It is pre-arranged planning. Presence of common knowledge, common design. B is the answer. It is mentioned where? Section 34 of IPC. Next 91. A knowing that B has murdered Z assists B to hide the body with intention of screening B from punishment. A is liable to. This is illustration to section 201 IPC. And the punishment is 7 years and to fine also. A is the answer. Next 92. A is the paramour of Z's wife. She gives valuable property to A which A knows belongs to Z and A takes it dishonestly without any authority of Z to give away. A has committed offense of theft. A is the answer. This is an illustration in section 378 IPC. Theft. Next 93. Which of the following is not an essential element of theft? There must be dishonest intention, yes. Removal from possession, yes. Immovable property, no. Without consent of the person in possession, yes. So C is the answer, not essential. Section is 378 again. Next 94. For the offense of abduction of person, abducted must be minor or major, doesn't matter. C is the answer. Next 95. Which of the following is not an essential element for offense of kidnapping? There must be a minor, yes. Intention of the accused, not relevant. Without the consent of lawful guardian, yes. Beyond the control of lawful guardian, yes. So not essential, B is the answer. Again, kidnapping from lawful guardian mentioned where? Section 361 IPC. Next 96. Under IPC, attempt to commit dacoity is punished under section. See, this is a controversial question. How? Section 393 mentions about attempt to robbery, okay, and 395 is the punishment for dacoity. The definition of dacoity in section 391 mentions it when 5 or more persons conjointly commits or attempt to commit a robbery. So attempt to commit robbery is included in section 391 and punishment for that is provided in 395 obviously. So it must be 395. But on one side, when it mentions attempt to commit robbery, it means it included in 391, which is punished under section 393. So I would say that punishment for attempt or committing dacoity is mentioned in section 395 itself. C is the answer. The answer key mentioned section 393. Next 97. In which of the following cases it is settled that death sentence should be awarded only in rarest of rare cases? It was Bachchan Singh vs State of Punjab. C is the answer. R versus Govinda, differentiation between 299 and 300. Husnaira Khatun vs State of Bihar. It is on right to speedy trial. Sunil Batra vs Delhi administration. It is on jail reforms. Next 98. In which one of the following circumstances the right of private defense of the body extends to causing death? Reasonable apprehension to cause simple hurt, या फिर simple theft, reasonable apprehension of causing wrongful restraint, या फिर enact throwing or administering acid or such an attempt that reasonably cause apprehension of grievous hurt. D is the answer. And right to private defense extend to causing death. It is mentioned where? In section 100 of IPC. Next 99. As per IPC, the gang rape is punished under section 376D. C is the answer. Next is 100. To which one of the following word illegal used under section 43 IPC is not applicable? Which is an offense? It is applicable. Prohibited by law? Yes. Furnishes ground for civil action? Yes. Which is immoral? No, it is not. So D is the answer. Next 53. Causing of death of child in the mother's womb is not homicide as provided under explanation 3 to section 299. D is the answer. This is a repeat question. There are several questions which repeats every year. Either they just change the language of the question, but the answer is always same. The provision is always same. Next 54. Section 511 does not apply in the case of attempt to rights. Yes. Where the provision for rights in 146, theft 378, FRA 159. Attempt to murder, there's a specific provision under section 307. So 511 is for attempt. So if there is specific provision for attempt to murder, then 511 will not be applied. So D is the answer. Next 55. Assault cannot be caused by mere gestures, words, preparation. Mere words. B is the answer. Next 56. Personating a public servant is an offense under section 170 IPC. C is the answer. Next 57. The Supreme Court of India has observed a clear distinction between dishonestly and fraudulently in case of Vimla Dev versus Delhi administration. D is the answer. Very common question and a repeated question. Next 58. The minimum duration of imprisonment provided for an offense under IPC is imprisonment for 24 hours. Yes, but what is 511? We just discussed this. It is for attempt. So it is in section 510. So B is the answer. Next 59. The principle underlying in section 95 of IPC is de minimis non curate lex. Repeated question. A is the answer. Non compos mentis is in section 84. Actus me invito factus non est mens actus. This is for section 94 IPC. Next, section 97 IPC expressly states that right of private person is subject to restriction contained in section 99. A is the answer. Next, 61. The language of part 3rd of section 105 is similar to that of. Now, I would say this is a controversial question. So, 105 of what? 105 in IPC is a commencement and continuation of right of private defense. And the answer key was given for 39. 39 is voluntarily. And 37 is cooperation by doing one act of several acts. 38 is person concerned in criminal act may be guilty of different offense. And 40 is definition of offense. So I did not find this question in proper way. Next, 62. Which of the following section of IPC has incorporated the English law known as principle of second degree? That is section 114. A is the answer. It is about abatement. And abater is present when offense is committed. Next, 63. The definition of criminal conspiracy in section 120A IPC has taken form that given in Quinn versus Latham. B is the answer. What is 120? Next, 64. Homicide cannot be defined as killing of a person by a person in view of the nature of definition of the word person in. Now they are asking me the definition of person. Person in section 11 IPC. B is the answer. 13 is deleted. It was green. 9 is number. And 7 is sense of expression. Next, 65. The requirement of possession has been highlighted by illustrations. In which illustrations of section 378? What is 378? Definition of theft. And which reflects the requirement of possession? C, D, E, F. C is the answer. Now see, this is a difficult question, I would say. So you need to just write in the Bayer Act. Just write down in your Bayer Act in front of C, D, E that it is illustration of requirement of possession. Next, 66. Theft under IPC differ from larceny in English law, which contemplated permanent gain or loss. A is the answer. Next, 67. A instigates B to murder C, who refuses to do so. A is guilty of abatement to commit murder. A is the answer. And this is illustration. A in section 108, abatement. Next, 68. Which one of the following brings out distinction between section 34 and 149? See, this is a repeat question, isn't that? Section 149 creates specific offense. 34 does not. It is correct. 34 creates specific offense. No, the two are contradictory. So if one is correct, so another is incorrect, obviously. 34 as well as 149 create specific offense. No, does not create. Do not create. No. So A is the answer. Next, 82. The right of private defense of property extend to causing death when offense apprehended is theft, dacoity, mischief, or house trespass. Dacoity. B is the answer. And where is the right of private defense of property extend to causing death? Section 103 IPC. Next, 83. In which of the following section 124A of IPC was added? That was in 1898. D is the answer. Next, 84. Which of the following statement is not correct? Common intention itself an offense? No. Abatement may be done by conspiracy? Yes. Criminal conspiracy is defined in section 128. This is correct. So A is not correct. A is the answer. Next, 85. A voluntarily burns a valuable security belonging to Z intending to cause wrongful loss to Z. A has committed the offense of mischief. B is the answer. And this is illustration A to section 425, mischief. Next, 86. When two or more persons by fighting in a public place disturbs the public peace, it is called as affray, defined in section 159 IPC. A is the answer. Dirty is mentioned in where? Writing is mentioned in section 146, unlawful assembly 149, public nuisance 268 IPC. Next 87, assault in order to outrage the modesty of a woman is punishable under section 354 IPC. B is the answer. Next 88, under IPC, which of the following is not grievous hurt? Emasculation, yes. Dislocation of bone, yes. Permanent disfiguration of face, yes. Any hurt which causes the sufferer to be during the space of 15 days, no, it is not. It shall be 20 days at least. And this is mentioned in section 320 IPC, grievous hurt. Key definition of grievous hurt. Not correct is D. D is the answer. Next 89, taking out movable property from the possession of a dead man is offense of criminal misappropriation, mentioned in section 404. C is the answer. Theft is defined where? 378, extortion 383. This is 90, in which the following case Supreme Court has struck down section 303 IPC as unconstitutional. Very common case, that is Mithu Singh versus State of Punjab. A is the answer. Next 91, which of the following section of IPC is related with causing death by negligence? That is section 304A. B is the answer. Next 92, which of the following section of IPC is based on the maxim de minimis non curate lex? Trivial harms shall not cause a criminal action. So this 95, D is the answer. Next 93, match the correct option. Public nuisance, I just mentioned this section 268 is incorrect. Harboring the offender 212, this is also incorrect. Fabricating false evidence 192, this is correct. Affray is, I just mentioned, in 159. 146 is rioting. So which is correct? C. C is the answer. Next 94, Durham's rule related with insanity. A is the answer. Next 95, which of the following is not an essential element of common intention under section 34? Criminal act done by several persons, yes. In furtherance of common intention, yes. Pre-arranged plan between person doing criminal act, yes. Act done in furtherance of common intention. So B and D are contradictory. So only one is correct. So B, if B is correct and D is incorrect, so incorrect is asked here, not an essential. So D is the answer. Next 96, which of the following is not a valuable security? Rent note. It is postal receipt for an insured parcel. No, it is not. Yes, obviously. Promissory note, yes. Deed of divorce, no. D is the answer. Next 97, use of violence by a member of an assembly of 5 or more persons in furtherance of common object will constitute the offense of rioting. C is the answer, where it is mentioned in section 146 IPC. Unlawful assembly mentioned where? 141. Assault 350. And affray is section 159 IPC. Next 98, the case of R versus Dudley and Stephen is related to the defense of necessity. D is the answer. Next 99, which of the following case is not related to criminal attempt? Sudhir versus State of West Bengal, yes. Abhyanand Mishra, yes. State of Maharashtra versus Yakub, yes. State of Rajasthan versus Om Prakash, no. D is the answer. Next 100, valuable security is defined in section 30 of IPC. D is the answer. Next 66, the difference between section 34 and 149 CRPC is that in section 34 there must be at least 5%, no. It is vice versa, 2 in 34 and 5 in 149. This is wrong. 149 is a rule of evidence where a section is specific offense. This is also vice versa. 34 is a rule of evidence and 149 is specific offense. Then requires active participation in action, whereas 149 requires mere passive membership of unlawful assembly. This is correct. then need not be joined the principal offense, whereas section 149 be combined with the principal offense. This is wrong. C is the answer. 34 is common intention and 149 is common object. Next 67. A takes a girl out of the custody of her lawful guardians. The following statement is complete defense if A is charged under section 361 IPC for kidnapping on the ground that girl was below the age of 18 years when taken away. तो डिफेंस बताना है यहाँ पे. द गर्ल वाज स्टूडेंट इन कॉलेज एंड कुड अंडरस्टैंड व्हाट द राइट और रॉन्ग, या फिर गर्ल वाज मेल ट्रीटेड बाय द गार्जियंस, या फिर गर्ल लुक्ड मोर देन 18 years of age and accused had satisfied himself that she was more than 18 years of age. Even all these are satisfied. There can be no excuse if she is less than 18 years of age. So D would be the answer. Next 68. Y picks X's pocket. Next day, X, while buying pan near his office, finds Y paying money from X's purse. X catch hold of Y and tries to take back his purse. Y resists. X twists Y's arm in such force that it is broken. X is charged with causing hurt to Y. X can say that he was acting under the private defense of property. No, Y cannot raise the plea of right to private defense since he had time to seek help of public authorities. Exception आ गई ना RPD की. When you have time to recourse for the public authority, then you cannot exercise your right to private defense. B is the answer. Next 69. Consider the following statements. A person is not guilty of dacoity unless he has committed, attempted to commit, or aided in committing robbery. Yeah, this is correct. When two persons conjointly commits robbery, every person so committing robbery is said to commit robbery. This is also correct. Both are correct, both are true. A is the answer. First, there must be robbery, and if there are 5 persons, then it becomes dacoity, obviously. And one person is doing robbery and another is assisting him, and obviously both have done the robbery. Next 70. Under which of the following situations would the Indian courts have jurisdiction? Crime committed by an Indian in a foreign country, yes. Crime committed by a foreigner in India, yes. Crime committed by a person on an Indian ship, yes. According to section 3 and 4 of IPC, all are correct. D is the answer. 1, 2, 3 are correct. Next 71. If actus non facitarium nisi mansitria is cardinal principle of criminal law, then which one of the following statement correctly reflects the above principle? Mens rea is an essential element of a crime, and there cannot be crime without mens rea. This is a general statement. However, there are some crimes such as this kidnapping, just did the question, and bigamy, and there are several other offenses. Then criminal liability under Indian law always implies mens rea. Not necessary. To constitute a crime, there must be actus reus and mens rea. This is correct. Actus is not always necessary. No. C is the answer. C is perfect one. Next 72. A, having delivered money to his servant to carry out a distant place, disguise himself and robs the servant on the highway with an intent to charge him. A commits the offense of robbery or what? Obviously C is the answer. Next 73. X, with a view to murder Y, enters Y's bedroom at night when Y is out of station. X is guilty of, this must be house breaking by night under section 446. However, the mentioned options are only house trespass. So you can say house trespass, but this is not a correct answer. This is not the correct option actually. Next 74. Which one of the following is sufficient to prove the offense of sedition? Comment expressing disapproval of the policies of the government with a view to obtain a change in policies of by lawful means. This is not. Proof of disloyalty, ill-feeling, no. Comment expressing disapproval of administrative action even though these do not excite hatred, no. Exciting disaffection towards the government. However, this provision has now put in abeyance by decision of Wombat-Kere versus Union of India. This is decision of year 2022. Where is the provision 124A IPC? Next 75. Which one of the following conclusion can be drawn from maxim de minimis non curate lex? Necessity knows no law. No. Nothing is an offense done by child under 7 years of age. This is doli in capex. Every person is liable for his own act. Triple acts do not constitute an offense. D is the answer. This relates to section 95 IPC. Next is 76. Which one of the following cases pertains to misuse of section 498A IPC? So the answer is Priti Gupta versus State of Jharkhand. B is the answer. Next 77. Which one of the following cases pertains to constitutionality of section 377 IPC? See, Vishakha versus State of Rajasthan is on sexual harassment at workplace guidelines. Alright. And this case was Navteej Singh Johar versus Union of India. C is the answer. Next 78. Which one of the following cases pertains to constitutionality of 497? That was Joseph Shine versus Union of India. A is the answer. And 497 was held unconstitutional. A is the answer. Next 79. Which one of the following cases refers to conspiracy under section 27 of Indian Evidence Act? That is Pulkari Kotaiya versus Emperor. A is the answer. बहुत ही common question है ये तो. Next is 80. Under which section of CRPC a person who is avoiding execution of a warrant may be proclaimed absconder? That is 82. C is the answer. So friends, here we have discussed all the questions of IPC which came in the exam paper of Jharkhand Judicial Services from the year 2008 to 2018. अगर आपको इसमें कोई कमी लगी हो, कोई सजेशन हो, कोई एडवाइस हो, कोई कमेंट्स हो, तो आप जो है अगर आपको इसमें कोई कमी लगी हो, कोई सजेशन हो, कोई एडवाइस हो, कोई कमेंट्स हो, तो आप जो है कमेंट सेक्शन में जाकर भी लिख सकते हैं. वी ऑलवेज अप्रिशिएट योर कमेंट्स. एंड अगर आपको ये वीडियो अच्छी लगी और एफर्ट्स हमारे अच्छे लगे हो तो उसको ज़रूर लाइक कीजिएगा, शेयर कीजिएगा अपने फ्रेंड्स के साथ, सो दैट दे कैन कम टू नो अबाउट आवर चैनल एंड वो भी बेनिफिट ले सकें. एंड अगर आपको हमारे एफर्ट्स अच्छे लगे हो तो इन एडिशन टू लाइक एंड सब्सक्राइब काइंडली गिव अस अ सुपर थैंक्स. सुपर थैंक्स इज अ वे टू अप्रिशिएट द कंटेंट क्रिएटर. आप जो है जो भी कंटेंट बनाता है उसको अप्रिशिएट करने के लिए कोई भी अमाउंट जो है डोनेट कर सकते हैं. तो काइंडली गिव अस अ सुपर थैंक्स. सो फ्रेंड्स, थैंक्स वेरी मच फॉर वॉचिंग दिस वीडियो. थैंक यू.